The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good afternoon. We have two cases that will be submitted. The first case is designated as PM and CM versus TB and DB. The second case is captioned State of Iowa versus Deshaun Marvin Lamar Williams. That second case is now submitted to the court without an oral argument, and we'll proceed to hear the arguments in PM. Mr. Cassidy.
If it may please the court. So there are two general groups or areas of inquiry. One, under Iowa law, statutory and public policy. Is this contract enforceable as written? Two, is the enforcement of it constitutional? Put another way, would enforcement of it violate the due process or equal protection rights of baby H or of TB? I think it's important to observe right from the beginning that this case comes to the court on a motion for summary judgment, so that there was, not only was there no fact-finding, but there was no real consideration of some of the most vital aspects of a state such as Iowa. The people of Iowa are being asked to enforce this contract, which cuts against every single statute and public policy that you have. There's nothing in this record, and there's nothing for this court.
What Iowa statute is violated by this contract?
First and foremost, the concept that a woman who carries a child can have her rights terminated based upon a written document that was executed prior to the birth of the child. There is absolutely, positively no authority for that. So in effect—
Does it matter that it's genetically, it's not her child, it's a child with the genes of other people she agreed to carry?
That goes without saying. I mean, that's obvious that this is a gestational carrier agreement. So
what's the significance of the Iowa criminal statute that exempts surrogacy mother arrangements from the criminal prohibition on buying and selling individuals?
If I may give a response to that, we have a moment. So we have some sovereigns, state of Michigan, state of New York, all of the countries in Europe that criminalize surrogacy. Then you have some jurisdictions like California that has made— Does
the United Kingdom allow surrogacy agreements?
Not right now, no. So they don't enforce them. And the EU—
Do they prohibit them?
Yes, and as in the EU, as we point out, the EU has declared that surrogacy agreements are human rights violation, that they're exploitive of the woman, and their focus is on the woman. I want to talk about the child too, which is very critical. But to answer your question, so we have some jurisdictions that will enforce the contract against the will of the mother. But then you have, in the middle, some jurisdictions like New Jersey, where there's no specific criminalization of the conduct, but they refuse to enforce the contract. So in response to Your Honor's question, so you have a statute that says, we're not going to criminalize this conduct. That doesn't mean that they're going to enforce the contract, number one. But number two is, I think we pointed out, and we had expert testimony on the fact that that rare exception to the criminalization of selling a child applies only to a situation where there is an artificial insemination. That statute was passed in the— Your legislature has never deemed it appropriate to amend it to include the conduct here. Now, Dr. Caruso has submitted an affidavit, unrebutted, Not only is the scientific and medical evidence that we put in such that it has to be on a motion for summary judgment, we have to defer to it. And beyond that, it's uncontradicted.
Under Iowa law, we have this rebuttable presumption that if the child is born and you're married, that the husband is the father. But it's rebuttable if you can show the genetic material. DNA testing says it's not the child. Where under Iowa law do we have a presumption that the person who carries the child is the biological mother?
Okay. As a matter of fact, she is. And that's the point of one of the points that we're making here. We have the scientific evidence that says that she is the biological mother. We ultimately get to that question of whether or not she is a biological participant. But I want to put aside for a minute the legal status.
But I want to know where she is a biological mother under our law. I mean, answer that question.
The law doesn't directly address it, except for the fact that every part of your law and your administrative code that talks about birth certificate says the woman who carries the child her name goes on the birth certificate because it's self-evident. Now, let me take a moment to
When the law was written 100 years ago, it was self-evident, but, you know, again, I asked you the question, where does it state under our law and under our case law that just because you carry a child makes you the biological mother?
let me answer this question my way as directly as I can. Okay. You won't find a statute that says that. Just like you won't find a statute that says that the mother has to be genetically related. The legislature has not addressed this specific situation. But what the legislature has said, and the only way that I can understand the statute, is that for purposes of legal status, not factual status, and this is a critical distinction because under the Supreme Court decisions, U.S. Supreme Court decisions addressing the constitutional rights of the woman who carries the child, it's the fact that she carries the child, that relationship, that awesome, amazing, physiological changes that take place with the child and the mother. And that relationship has always been considered the core of all civilized society. So,
But counsel, didn't all those cases involve, it was her own child genetically, it was her egg, the U.S. Supreme Court decision?
this case has not gotten to the U.S. Supreme Court yet, and facts of this case has not gotten to the U.S. Supreme Court yet, but what the Supreme Court has always said, and I'll remind you, the 2001 Supreme Court case in Nguyen, okay, comes years after gestational surrogacy is not only in the news, but in reported opinions. It reaffirmed the concept that the carrying of the child and the giving birth establishes the relationship that is protected by the 14th Amendment. So there are, Judge, two different points here. One, is she, as a matter of biological fact, a mother? What has made a mother a mother? A mother hasn't been someone who just donated genetic material. This is what always distinguished a mother from a father.
We have this area of law, and it's really developed around fathers because this is the first case that's come up here dealing with mothers. But we have this body of law that someone who acts like a father but is not genetically determined to be the father through a paternity test is not required to pay child support, not required to do all the things under the code that is required of a father. This is the first case we've seen where the mother is not genetically related. So I guess, are you just telling me that the relationship changes because she carried the child and the genetic material doesn't mean anything?
Oh, no. I'm not suggesting that you would have a very different case here if the woman who donated the ova was not anonymous, did know the child, wanted the child, and so you had two women. This is what the California
But
case was
that's
about.
not the case, though. We don't have that
No, it's
here.
not. So what we have is a district court who says this child has no mother. No mother is a matter of law. The district court says we can't recognize her as a legal mother because in a hypothetical case that may come down the line, if a second woman steps forward and claims legal status, then there'd be two mothers. Well, there would be two mothers as a matter of fact, but there may not be two mothers as a matter of law. So in order to avoid what the district court thought was an absurdity, the district court embraces the absurdity that this child has no mother.
Counsel, could you address the Iowa Department of Health regulations that provide for this surrogacy type arrangement by putting the intended mother and father on the birth certificate?
Yes. I'm glad you asked the question, Your Honor. It's not dissimilar to the business of that statute, which we didn't fully address yet, and that is the difference between artificial insemination and in vitro fertilization and the difference in the harms. But with respect to your question, okay, Section 6F is controlling. So what does it mean? It means this. It means that despite the fact that the legislature has never expressly endorsed this conduct, despite the fact that the legislature has never expressly said these contracts are enforceable, that people are doing it anyway. So giving to the reality that there's some people, like those in this case, that have engaged in this conduct, which is unauthorized, in many ways lawless, there has to be a mechanism to put names on a birth certificate. Because if you have a situation where TB walked away from the child, surrendered the child, who's going to be the legal mother? So there's no statute that they'll enforce it. So what does it say? It says that if TB consented to an adoption under 600, then CM could go through an adoption process, which of course requires her consent, and then she would have to have a court order appointing her legal status. Today she has no legal status. The district court recognized that she has no legal status. And the district court recognized that there was no authority for him to force through an adoption.
Let's assume science advances and you're able to have gestation outside of a womb, in an artificial womb, where there's no woman. What do you do in that situation?
Write a statute, first of all. And that's the problem, that these problems are created by people, and the people of Iowa is being forced to use the weight of its collective power through its courts to try to accommodate people when there is no mechanism.
The problem is that the law never keeps up with science. I mean, it'd be an ideal world if we can do something in advance, but it appears, you know, and all these cases that come up, the law and the science sort of don't mesh together.
At some point, after gestational surrogacy, which has been around since the year 1989, and I'm aware of probably before that, when the legislature doesn't act to make the contract enforceable, at some point there has to be an inference or conclusion that they didn't act on purpose. And the court, and the district court, is not here to replace the judgment of the legislature, rewrite the statutes, which is what they're doing.
By not acting, does it mean that they didn't think that the normal contract principles apply, or that they thought it was illegal? We don't know what they meant by not acting.
Well, they had enough time to tell you. And the fact that they didn't, I don't think gives the court the authority to adopt the powers of a legislature to write the statutes that they chose not to write. Constitutional rights that we're talking about here. Let's talk about the child for a minute. The district court, in effect, said the child has no rights. This court has said that the children have look at what we're talking about here. They're coming to court saying, we want you to sanction the creation of a class of children who have no mother, as if the relationship that a child has beginning in utero has no value to the child. That's the only mother this child knew. There were dynamic physiological changes in a mother's brain.
So what if, I'll vary the facts a little bit, what if in this case the ova was provided by CM, the intended mother?
Then you have the case of Johnson versus Calvert. And what Johnson versus Calvert, and I'm not advocating Johnson versus Calvert. I'm just saying that one court decided that case. They did not enforce the contract. And what that court said is, the surrogate is in fact biologically a mother of the child in a way that forms a basis to confer legal status upon her. But they said, on the other hand, we have the wife who had the physical custody of the child at that time, married to the genetic father, and in that case they said, look, we have to break the tie somehow because we say you can't have two mothers. Here the district court said they have no mothers. They said you can't have two, so we have to figure out who we're going to confer, and all they're talking about was conferring legal status, and they felt compelled to pick between the two, and under the unique facts of that case, they said we're going to, under all those facts, we're going to confer it on the mother who is the wife. So, now, it says stop.
You may sum up, and you'll have rebuttal.
Yeah, there's a lot to talk about, isn't there? So, the commodification of the child. Are we ready, is Iowa ready to go down a path where a court says, we're irrevocable path to say we can buy and sell children? This is worse than selling children. It's the manufacture in advance of conception for the purpose of selling the child. And in this contract, no money was going to exchange hands until the birth mother surrendered her rights, submitted to termination, and gave custody of the child. If that's not exchange of a child for money, I don't know what is. Thank you very much.
Mr. Cassidy, thank you as well. Mr. Koster.
Mr. Chief Justice, thank you. May it please the court. I'm here along with my co-counsel, Casey Rigdon, representing the M's, a couple who married later in life, wanted to have a child, couldn't conceive naturally, found a willing egg donor, a willing surrogate, entered into a contract with the willing surrogate.
Let me ask this question, and I'm sorry to interrupt you early, but I want to get to this. The statute is clear, the criminal statute's clear, that it only applies to artificial insemination and not IVP. So under what basis did your client have a right to enter into this contract?
There are sort of two divergent answers, so I'll try to give you both of them, Justice Wiggins. The first one is the case that the statute is designed to address what's commonly called traditional surrogacy, where the woman who gives birth is also genetically related. That statute really expresses the public policy of the state of Iowa. It was passed a year after the Baby M case out in New Jersey, which wouldn't enforce the contract, and far from criminalizing it, said, look, this isn't a criminal action. And so we don't generally need statutes to allow contracts. And this statute addressed a situation where this woman would have a genetic connection to the baby, thus have rights, so it wasn't sale for her to give up that child to the intended father. Here we don't have that genetic connection, so we don't have the risk of the criminality. We don't have those things because we're not selling children. The gestational carrier is being compensated. The consideration is for her services in gestation. The genetic material was always in the possession of the M's to start off with. they would have never given it to the B's had they not known that at the end, their child would be coming back to them. And, they never intended to donate genetic material. I mean,
I understand what they intended, but what is the legal basis for entering into that kind of contract?
well, when we're looking at legal basis, the general assumption in Iowa, the Deere case tells us, is that contracts are valid unless they violate a really clear public policy. And we just don't have that clear public policy in Iowa against surrogacy. We have, immediately after Baby M, the legislature says, this isn't criminal. Then we move on. We have the Calendar case that says science helps us determine what paternity is and paternity is in that case, and that just because parental rights arise in non-traditional means doesn't make them any less fundamental. The parental rights here belong to the M's. Then we get to the Witten case. The Witten case is a divorce case, and the court in that case found that the contract wasn't enforceable between a couple, but it said very specifically that it was enforceable in the arm's length side of it.
But if you lose this case, the father's still the father, and the father may be required to pay child support under our traditional things, and the father would be entitled to visitation and have access to the child. And maybe the father could even get custody of the child under a custody agreement. I mean, isn't that the chance you took by entering into this contract without any clear legal parameters?
Well, again, I don't think there need to be clear legal parameters in the sense that there's some sort of authorizing statute.
How about any legal parameters instead of clear legal parameters?
Well, the parties did enter into the contract. The regs were in existence. I mean, under color of that law, they entered into the contract saying that this procedure could be followed post-birth to align with the party's intention. I mean, certainly if the Department of Public Health thought this was a terrible, horrible, no good, very bad thing, it wouldn't have put out regulations to say this is how we get there.
So here, let me tell you kind of what bothers me about this case on a gut level, Mr. Koster. We have on the one hand, we have all these laws about adoption. A mother carries a baby to term. There's a decision about adoption. There are all kinds of legal hoops that have to be gone through. There's all opportunities for the mother to back out. There's all kinds of due process and all of that before the decision becomes final. Here, a mother carries a baby to term, and because there was a contract, which one could argue is a fairly one-sided contract to benefit your client and not benefit the B's in particular, that's it. They're all done. No due process, no nothing. No, I mean, isn't that kind of a strange way for the law to work in a broad sense?
Not necessarily, Justice Mansfield. The presumption that she has rights as opposed to legal presumption is a really big presumption in this case. I mean, we don't have any Iowa law, as Justice Wiggins was asking. There is no Iowa law that says that the biological mother is the same woman who carried the child. There's never an equating of those two things in the law. So when we're looking at this, I mean, we have to look at what are the respective rights. Parental rights arise out of blood relationship plus acting on that relationship. Well, the blood relationship is absent here as it relates to the surrogate.
Did the contract anticipate the existence of the scientific evidence that Mr. Cassidy refers to concerning the relationship that is built by carrying a...
I'm not sure I understand your question, Your Honor, about did the contract anticipate that?
Yeah, did the parties contract have any provision that contracted for what the plaintiff's claim is all about?
The parties' contract did talk about that she would agree to give up any rights that she had, and the surrogate, Ms. B, had been pregnant before, so she understood when entering into this that there might be some there would be changes to her body, there would be those things, but yet no one was coercing her. Back to Justice Mansfield's question a little bit, the reason we have all this due process in the adoption and we don't allow contracts about adoption and termination is those typically occur while the woman is pregnant, which is problematic. But here we don't have that. We have some parties, the M's, with genetic material, and Ms. B, who finds the M's and says, yes, I'll do this for you. I mean, she was the one who proposed the consideration. No one strong-armed anyone into the contract. Everyone signed it voluntarily. And
Well,
so,
that may be, but let me share with you my problem. On the one hand, I think we would all agree you can't sell children. That's, yeah, I mean, it's kind of an extreme hypothetical, but no one's going to say. On the other hand, we'd all agree you can sell corn. All right? The commodification, if you will. What we've got here is something kind of in between. This gestational relationship is not, I suppose, a full-blown, quote, mother relationship with genetic material. So, yeah, it's not fair to say that the gestational relationship is solely an objective relationship. It involves, as the scientific affidavit suggests at least, kind of considerable relationship with the now born child and chemical and emotional interests. So, admittedly, and obviously this is not quite the sale of a child, but it's also not the sale of corn. It's kind of in between. The law intervenes to prevent certain contracts from being enforced on public policy grounds when it's just thought to be not the kind of thing that should be bargained away. And I'm struggling with it because I don't think it's really clean. I think it's kind of in between. The law hasn't anticipated it. Our code hasn't anticipated it. So help convince me that this is more akin to, this should be more enforced on the sliding scale than what the UK might suggest.
sure. So the first answer the court can find in Johnson v. Calvert and the California court said basically the suggestion that a woman doesn't have this much autonomy over her body to make this economic choice harkens back to a time where women didn't have economic rights. So that's one starting spot to say, look, in Iowa law, we treat men and women equally, and a woman should have enough autonomy, freedom. This court shouldn't intervene to say, you can't enter into that contract about your body. The second thing we find, Iowa law, not directly certainly, does contemplate the use of a surrogate in one specific instance. If you look at the probate code, in 2011, the Iowa legislature passed a statute that allowed posthumously conceived children to have inheritance rights. If the surviving spouse had genetic material that was left by the deceased spouse, that child, the surviving spouse could use the genetic material to have a child, and that child would receive inheritance rights from the deceased child. Now, in the case of a woman, if there's genetic material that's left, the woman could have it implanted into herself, carry the child. But if the surviving spouse is male, and the legislature makes no distinction here, if the surviving spouse is male, what's he to do besides use a gestational carrier? I mean, there are no, as we were talking about, artificial uteruses that can carry a child outside of a woman. So the legislature said, yeah, okay, if you want to use the genetic material and have that child, then that child receives inheritance rights from the deceased spouse, the mother, thus suggesting that relationship. The third answer is that parental rights in all of the Supreme Court cases cited by the appellant, in all of this court's decision, come from two things: genetics and relationship. So you're talking about the relationship. And all the scientific evidence talks about relationship, chemical changes, all those things. Even assuming all that's true, the genetic component is missing. And if the court were to go down the vein of saying, well, relationship somehow gets you over that hurdle, you have a real problem. I mean, there are countless situations where grandparents, say, have a better relationship, a more direct relationship with their child than do parents for any number of reasons. And it would be dangerous to just say, oh, well, somehow relationship can get you in the door.
Well, I don't think I can see horribles on all sides here, unfortunately, and but the principle of law for this case could be quite narrow. It involves a situation where there's a gestational mother, where the parties to the contract do not include genetic egg, and so there's not like the two-mother competing circumstance, and we could easily narrow the decision to simply say, under the facts of this kind of case, we won't enforce a particular contract.
I suppose you could, but Iowa law does have one answer that we haven't talked about yet. So we have one genetic parent, and if you look at the Beathard's case, it quotes Smith v. Offer, the U.S. Supreme Court case, that said that biological parent has a liberty relationship over and above anyone with a other kind of relationship. That was a foster family in that case, which again might have a really significant, vital role. This court also in the J.C. case and those other cases have talked about, these people in Beathard's, in J.C. it was 2 years of relationship where the guy held him, well, I don't want to say father, but the male held himself out as a father, and this court said, look, there are no parental rights to terminate. But if you get to all that, Iowa law does have one answer, and that's the marital presumption. There's only one person who's asserting a genetic connection to the child, that's PM. He's married. And if you look at the Gartner case, everyone in the Gartner case knew that the other married spouse didn't have a genetic connection. But this court said, well, there are all these good reasons to make an established family, and this goes to Justice Wiggins' point earlier about
Gardner case, there weren't two families competing over the same kid.
No, that's correct. But in Gardner, it recognized, and Callender recognized, sorry, not Callender, but Tyler, that the inheritance tax case recognized the stability and sanctity of family and a stable framework for couples raising children. And the marital presumption helps accomplish that. And so applying the marital presumption here, saying that when we don't have the genetic connection, the next most important role, rather than the surrogate, is the spouse of the one person with the genetic connection, is most consistent with Tyler, with Callender, with Smith v. Offer out of the Supreme Court. And that helps answer this idea of, if you want to call it relative priorities, the court in
Gardner seems more applicable, though, when the biological father is married to the woman who's carrying the child.
Your Honor, I see my time has expired. May I answer the question and conclude? Gardner, well, when you say the biological father is married to a surrogate, then I guess I want to understand.
To his wife, and there's no genetic material of the wife in the mix.
Oh, in that context, certainly that might make it more applicable, but Gardner still stands for the proposition that assuring the opportunity for the family to enter onto the birth certificate, to assume those rights at birth, to assume those fundamental parental rights that exist in the parents at birth, involves placing the spouse on the birth certificate. I think that's what Gardner stands for.
Chief, could I ask a follow-up question? The opposing counsel noted the procedural posture where we have this case on summary judgment. Would we be smarter to decide the issues in this case after a full-blown trial? And what would the trial, what genuine issues of material dispute that would be resolved at a trial in this case?
It's correct. This case is on summary judgment. There are really no genuine issues of disputed material fact because the determination of parentage is a legal determination. That's an entirely appropriate issue for summary judgment. Sending it back to trial, I think, would really confuse the issue. What is it that we're going to determine? You know, the issue was who's a legal mother, and the law has an answer to that question. We submit the law's answer to that question is if someone with a genetic connection and a relationship, and in the absence of that, then we don't have a legal mother, which, not to answer more than the question, but Iowa law contemplates that. It says a single person can adopt. I mean, we have situations all the time where there's only one parent, including maybe a male, only a male on a birth certificate. That doesn't offend Iowa law. And so for all those reasons, A, I don't think there would be much to determine at trial, and B, we'd ask that you would affirm the decision of the district court.
Mr. DeCoster, thank you. Mr. Cassidy?
Thank you, Your Honor. Judge, I have 6 points. I'm going to try to make them in 5 minutes.
I want to interrupt you before you make your point.
Okay.
You know, you're claiming that this contract is not enforceable because of some public policy reason, but your client entered into it.
Correct.
Your client entered into it. They weren't under duress. They weren't under any things that we would say they were forced to sign this contract or do it. So why should they get the benefit of the violation of public policy when they are just as complicit as the other side in entering this contract and violating public policy?
Okay. First, we can't lose sight of the benefit to the child. That the child is being deprived of the mother who carried her, who she got to know, whose scent she knew, voice she knew, heartbeat she knew, all the rest of it, the bonding. To deliberately set on a course to take pregnancy out of that relationship is terribly destructive. Terribly destructive. But let me answer you even more directly. That argument, if we were to accept it, okay, could be used to enforce every single contract that comes down the pike. And in fact, it would be the basis to say we're going to throw out the adoption laws altogether. Why? Because the woman who signs a contract when she's 6 months pregnant saying she's going to surrender the child to adoption, she's really, this is what the district court said, she's so smart it's insulting to her to say that she needs protection from herself. So every single woman who makes a promise to surrender a child to someone during pregnancy, that promise is going to be enforced because otherwise it's insulting to her. And as we point out in the brief, don't tell her to wear a helmet when she's on a motorcycle, so that's insulting to her. And don't tell anybody they can't sell a child because that's insulting. So there's two people being protected here. The mother who did not know the depth of her bond with that child. She couldn't will it away. Her sense of moral obligation to the child, she had every intention to surrender that child up until 1 week before the children were born. So
Why did communication break down earlier? There was a dispute along the way where she wanted additional money, perhaps double the original contract amount. It just seems like we're not in agreement on what the record shows.
Well, what the record shows, absolutely, without contradiction, is part of the exploitation issue. What happened right out of the box? She's told she was bleeding, she went to a doctor. She was told by CM, you're not permitted to go to a doctor without my permission first. You're not permitted to have your husband present at a doctor's appointment. We're the boss. We tell you what to do. We're paying you. You work for us.
Well, maybe there's remedies for that. I mean, that doesn't necessarily mean that the entire class of contracts are void as contrary to public policy. I mean, a fair case can be made that those burdensome requirements that were coming from one party were not part of the contract, in fact.
Well, let's look at the logical conclusion here. And I wish I could make these points, but in any event, where does this lead? If this court declared these contracts are enforceable, what are we, California? Do you know what happens in California?
Your client prevented this father from bonding with the child, being there at the birth, holding the child after birth, going to these appointments. I mean, who knows, what the science is, that when fathers get to do those things, the child bonds with the father also.
The child does not, during the pregnancy, bond with the child, and the studies that we cited in our brief say that the father has no changes in his brain. whatsoever,
Birth. At
even after birth.
At birth, when the child's born, the father usually spends time holding the child alone without any interest. All that stuff was taken away from this father.
So, but what happened here was that she was forced to make a moral judgment. She was forced to conclude that they would not be good custodial parents for all the reasons it's in the brief. Some of it had to do with disgusting language. And she determined, how can we expect a mother who's carrying a child to say that I don't care what happens to these children? How can the court ask the mother to disregard her sense of morality and moral duty to the child? You can't. Women aren't built that way. But one of the things that I wanted to point out is if we enforce these contracts, in California, you don't have to be genetically related. You can be 80 years old in a wheelchair and unable to raise a child, and the contract, they enforce it anyway. There's a case that says that even if the so-called intended father decided that he can't raise the children, doesn't want them, and will give them away, it's enforceable. There is no way to address those kinds of things without careful deliberation by a legislative body after years of study, at the minimum. The court here can't do all that. You can't possibly anticipate all this. I could tell you all the horror stories all day long. It would take all day. You can't anticipate them all. So the exploitation, what capped off the exploitation in this case, and a woman is entitled not to be exploited just because she can carry a child, just because she's a woman. What capped it off here is while she was worried about the child, and the reason she didn't tell them about the child is she didn't expect they were going to come so soon, and their lives were threatened, and she wanted to focus on helping them right then and there, and this contract put her in that position. So we have a court order here where a judge ex parte terminated the rights of this mother, instructed her to turn the children over immediately, and that she couldn't do anything inconsistent with the contract, which meant that she couldn't even she couldn't even litigate, and she couldn't even raise the constitutional rights. And she didn't even know there was a lawsuit. To me, that order demonstrates that contract means to some people that the mother has not only does she doesn't have any rights, she's not entitled to any consideration whatsoever, even a simple service and notice of process. I'm past my time unless you have more questions. I have more to say, so I better sit down.
Thank you, Mr. Cassidy.
Thank you, Judge. It's a pleasure to be here. It really is. Thank you, Judge.
Mr. Cassidy, thank you again. Mr. Koster, thank you. The case of PM and CM versus TB and DB is now then submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.